Welcome to the I Now Pronounce You Divorced podcast, where we have 3 award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hello, and thank you for joining into I Now Pronounce You Divorced. My name is Dan Cuneo, and today we are joined by 2 attorneys at Melone Hatley. We have Christa Atkins and Stephen Lukacs. Christa and Stephen, thank you for joining us today.
Thank you, Dan.
Oh. We were talking before we were starting as far as how cases are set and what is the tone and what is important as far as hearings and what strategy goes into that. And we were briefly discussing what you say in Virginia, which is PL, Pendente Lite. It's a hearing, but it's a temporary order, but it sets kind of the tone in the course of the case. And I thought it was a great topic that we can discuss for those who are joining in, and especially those who are going through any type of divorce case. More likely than not, they will experience some type of a PL issue or a case or a hearing. And so maybe we can go into a little bit of detail on what that is. And I'll ask both of you, and I'll start with you, Christa. What is a...
So a PL hearing is typically, the way I explain it to my clients, it's the first hearing that we go to in a divorce action. And it's going to establish some temporary relief during the pendency of the divorce. And so a lot of times that's not a great explanation, and clients are like, well, I don't understand. And so the best way that I can say it is that we don't want, for example, with young children, we don't want during the pendency of the divorce for one parent to withhold the children from the other parent. So we need to get something temporary, a temporary order in place that's going to compel that parent to share time. Also financially, we need to get something, some financial relief oftentimes to clients during the pendency of the divorce, because spouses are not always on the same level financially. Sometimes there's a high income spouse and there's a low income spouse, or there's a stay-at-home mother who's going to need support during the divorce. So it is just simply an order that will maintain a status quo while the divorce is pending.
And Stephen, we were talking earlier, how does one prepare for a PL hearing?
So the first thing you have to do is tell your client what will be presented and what cannot be presented. At a PL hearing, you cannot distribute property. That's a big one. The second one is they're not here to hear faults. They're not here to litigate the case about who did what wrong. It comes into factor with the children, but they don't care if there was adultery. They'll hear it sometimes, but they're not really supposed to. It's need-based support. So if you are the client who doesn't have any, or the spouse who doesn't have any money, because the other side has controlled the finances, it is your time to get that. If you've always had or always been the primary custodian for the children while the other spouse goes to work, there's your time to get it. And the reason it's so devastating of a hearing is because while you can't divide property, I've said many times to almost every client in the world, 9 times out of 10, you're getting a 50-50 divide if you go to court, especially with a judge who knows very little about your case. Mm-hmm. At a PL hearing, though, the big ticket items of child custody, child support, and spousal support will all be decided. They're not supposed to be completely finalized. It's a temporary order. But what happens most of the time is your final decree going to look a lot like that PL order. There's even a formula to stop fights on spousal support. Okay, great. Well, they're not supposed to use that formula at final trial. Will the amount you got at the PL hearing look a lot like what you got at final trial? So it really does. It's not supposed to. It says in the statutes, it's not setting a status quo, but the practical terms are those 3 issues might be decided very early in your case.
Christa, how hard is it if you have an appeal hearing and it's not favorable? Can you take it up to the next level, which I'm not sure in your jurisdiction, is it a circuit court? Is it the appellate court, or are they non?
So in Virginia, they're non-appealable because they are it's an order that's temporary in nature. You have to have a final order. So first of all, we're in circuit court because a Pendente Lite hearing is always going to be had in circuit court. They are not in the Juvenile and Domestic Relations Court, which does produce appealable orders. In the circuit court, your next option is the Court of Appeals. However, it can only be a final order. So these are not appealable orders. You are going to be stuck with this order. Parties are going to be stuck with this PL order until the final trial, at which time there will be a final appealable order.
Okay. And Stephen, when you have this potentially unfavorable order, what's the strategy look like from once you receive that order to the final hearing or trial?
Well, around here, your next step is to get to a judicial settlement conference, and this is why you need an attorney who's going to move. Because those PL orders, because divorces can take, it still blows my mind, years. My longest divorce trial has been a year and a half from start to finish. And that's because we did everything along the way. My average is like 9 months, but some people have, if your attorney is slow, 3-4 year divorces, and that order will stay in place the whole time. So if you get an unfavorable ruling, it's next steps. Next step is to get to a judicial settlement conference and try to get your case settled. Because the only way to get that modified is either to go to final trial, which is the step after the JSC, and make a better argument, get a different judge who's more favorable to your argument, or, okay, we've taken our body blow, let's get to the JSC and figure out what we can do. So it's next steps as always. Get to the next step and move. Don't sit on it. Now, I will one caveat though. If you're the party who won and you got all the money, well, I hate sitting. Christa hates sitting too. We are both very fast, but that is a maybe we sit on our hands moment. Maybe we chill out for a couple months. You collect your money. Let's bask in our win and let the other side figure out what they want to do.
So you're hanging on to the status quo and using that.
Yeah, and everyone does it.
Mm-hmm. What if, and I'm not sure in Virginia this happens at these PL hearings, but I'm sure the ruling is based on the evidence that was presented. So let's fast forward and say that the circumstances change. Can you go back and ask for reconsideration?
Sort of. You can always motion to reconsider. Whether or not they're going to take it up is entirely up to the courts. In my experience, Chesapeake will hear motions to reconsider a little bit more than Virginia Beach. But you have to remember, Virginia is a very weird state, and every county is going to change drastically. Mm-hmm. I'm from the Stafford area, and I can tell you that Stafford courts, if you got a criminal case in Stafford County, Virginia, good luck. If you got one in Fredericksburg, the prosecutors will talk to you the week before. They'll give you a phone call and give you plea deals. Literally, that Route 1 bridge changes the whole thing. That's how this place works. You go across that tunnel into Newport News and Norfolk, everything is different. So you need an attorney in the area who knows those courts.
And Christa, when you're preparing for these PL hearings, if you don't mind, walk us through what that trial prep looks like with the.
So when it comes to spousal support, one of my big evidentiary items is going to be the income and expense sheet. If I typically like to have discovery from the opposing side before PL, but that's not always the case. At a bare minimum, I will reach out to the opposing side and get that income and expense sheet, because we put those, both of the parties will list their income and what all of their expenses are and what is left over, or what they are in deficit each month. And I think that the courts really do rely a lot on those income and expense sheets when they are assessing spousal support, because like Stephen was mentioning earlier, the spousal support is based on the need of one spouse and the ability of the other to pay. So those are a big evidentiary item at the PL hearings. That also goes, that they also speak to the attorney's fees as well. I'm often at a PL hearing, I'm sometimes looking to get attorney's fees paid during the pendency of the divorce, and getting my client an award of attorney's fees, because I am representing the lower income spouse that doesn't have the ability to maintain the fees while the divorce is pending. And so again, those income and expense sheets show the court that this is the need. There's a substantial need for this money. The other things that come in with respect to child custody and visitation, it's basically going to be the role that the parties have played in children's lives, and the status quo. So typically the court is going to maintain a status quo with the children, give each party, the party that's probably leaving the marital residence is going to have some time with the child. It just really depends. That's a whole different ball of wax. It's hard to say what's going to come in, because every case is so different with custody and visitation. People are different, so it's hard to say what type of evidence will come in with that.
And speaking of evidence, Stephen, how difficult is it to object in these PL hearings? Are the rules of evidence adhered to, or are they a little bit loose?
It is the Wild West out there. And I have a good story. Your attorney is going to love the word objection in court, because it's the easiest way for an attorney to get out of a bind. Object and hope that piece of evidence is not entered. Some judges, like Chesapeake is my favorite place to go because they will let us, it is not even a lot of testimony. It's the attorneys just yelling at each other back and forth. And I prefer that chaos. Virginia Beach, they're going to be a little more structured. There actually is a procedure expert out in Virginia Beach, and he is going to make you lay those foundations for every piece of evidence. But I will say this, I was going to mention this, those income and expense sheets. Do not object. This is giving out a little bit of trial secrets, but you do not have to have your attorney object to a piece of evidence that has not been presented to early or before court. Some guy forgot his expense sheet once. I could have objected to it. You got 2 minutes to review a sheet you haven't seen before. I went through the sheet and found out that his income was not correct. He was double counting his mortgage and his interest, and he claimed he had $0 left over every month. So I got him on the stand and said, hey, when you press the button to pay your mortgage, what is it? Is it $2,500 or $3,000? Because you listed $3,000. And he said, I got it right here. It's $2,500. So when you say you have zero, you actually have $500 left over, don't you? Guess what I got for spousal support? $500. So that's how the evidence goes. It's very touch and go. I could have objected. Maybe the judge would have let it in. Maybe he wouldn't. I knew it was the Wild West, and I wasn't going to rely on the exact rule of I could get this out. I adjusted on the fly, let the evidence through, and used it for something better. Wild West, I'll be honest, I do not think, I hate saying this, your attorney matters very much for most of your divorce. I think any attorney can write a complaint. I think any attorney could go to a settlement conference. I think the big times where your attorney matters, PL hearings, final trial, initial consults. It's the beginning, middle, and end. Everything in between, somebody else could figure out how to do, but you need someone good to get those three things down right.
When we're talking about PL hearings and we're looking at strategy, Christa, when you are preparing your client, do you bring in witnesses as well, or is it just a client in the other opposing party?
It depends on the case. Every case is different, so it depends on the case. So if it is an issue of child custody and visitation, and my client has disclosed to me that the other party is a severe alcoholic that can't properly care for the children, and there is an independent witness that's going to testify to that, then I'm going to bring a witness in. And I'm going to try to get a PL order that either put some type of limitation or some oversight on visitation in that kind of a scenario. So it really depends. It's very case specific, fact specific, whether I'm going to bring witnesses into the PL hearing. And typically, we will set them differently. Now, I know in Virginia Beach, we're usually on a Friday docket, and we're limited. Our time is limited to maybe 30 minutes, an hour at most. If we're going to go over an hour in a PL hearing, we have to set the hearing differently with the duty judge. So it really depends as well how you set the hearing, as far as how long you expect the hearing to go. And if you're going to be calling witnesses, you're going to set it a little bit differently because it's going to be under a duty judge.
And you raise a really good point, Stephen. And I know we're up against time here for the podcast, but when you're looking to file the PL, from the date that you decide you want to file, how long is it between filing it and actual hearing? And then the second part of the question, is it retroactive to the date of filing for the PL, or can you get retroactive to the date of filing for the divorce?
Well, it's supposed to be retroactive to the date of filing, but again, it's the Wild West out there. It is, I don't know how many times I've been told, this is not just a court of law, Mr. Lucas, this is a court of equity. We're going to do the equitable thing. So argue what you want. Argue what you want. This is truly like, if you've ever seen a bad, I know all the lawyers would know this, maybe non-lawyers won't, but have you ever seen a bad procedural show where they're just getting things wrong in the law, and you're like, that's not how this goes. That's not how this goes. And I was wrong myself. It could go that way at a PL hearing. I've had one where they broke apart. I mean, we did like 3 sets of testimony back and forth on different, instead of one party going and then the other party going, it was like, let's hear one issue back and forth. Let's have the attorneys fight for 20 minutes. Let's go back and forth. And honestly, that's why Chris was talking about witnesses. I generally don't bring witnesses. It's fact dependent, but that hour, that judge wants to get this done in an hour. You should be putting on 20 minutes of good testimony, 10 minutes of argument, and sitting down with a simple, easy story. I have the need or I don't have the need, and get in and out of there. That's why they're so difficult, because final trials, you can go all day. You can prep all day for those. It's real hard to get a 20-minute succinct argument in.
So the 20 minutes, that 20 minutes each side, or 20 minutes that you have
20 minutes for each side. You got an hour. And if you go over that hour, some judges will throw you out.
Wow. So you need to really make sure that your client is prepared as well.
Yes. That's why I said they're devastating hearings.
You bring up court of equity, and that's such an ambiguous term. I just remember back in my litigation days, it's like, well, if you're saying equity, that really isn't fair, Judge, but okay. Well, I really appreciate both of you taking time to talk to us about PL hearings, because it's so important that you listen to your attorney, listen to their advice. But then also, if you don't get that favorable ruling, what do we do next? Because PL, they're temporary in nature, but there are potentially some things that we can do. If you're looking for advice, or you're going through a difficult time in your life and you're considering separation or divorce, or maybe you need a second opinion, give Melone Hatley a call, and we're more than happy to speak with you. Again, if you found this information valuable, please don't forget to like and subscribe. This is Dan Cuneo with I Now Pronounce You Divorce. Thank you.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.